Good morning. I'm Robert Chisholm with the law firm of Chisholm Chisholm Kilpatrick. Joining me today is Sarah Papantonio from the law firm of Levin Papantonio. Sarah, welcome.
Thank you for having me.
And we're here today to discuss Camp Lejeune, the issue of the litigation, offsets, and VA benefits. So what is the Camp Lejeune litigation? So veterans or their families who were stationed at or lived on Camp Lejeune, North Carolina, between August 1st, 1953 and December 31st, 1987, for at least 30 cumulative days, not consecutive days, any 30-day period, and if they develop certain cancers or other conditions, may now be eligible for compensation. And thanks to the Camp Lejeune Justice Act, those eligible can file a claim in the United States District Court for the Eastern District of North Carolina. However, compensation is subject to offsets for federal benefits for the claimed conditions, such as VA or Medicare benefits for the condition caused by Camp Lejeune exposure. So, Sarah, how long does someone have to file a claim?
So this is all going to be laid out by what is called the Camp Lejeune Justice Act. That is what gives us the ability to bring these claims now 40 years later. And what the Camp Lejeune Justice Act tells us is that we have 2 years from the date of enactment of that bill to file these claims. So that bill was passed in August of 2022, meaning that we have until August of 2024 to file these claims. After that date, you cannot proceed further with any of these claims. So you have 2 years to file.
All right, so essentially, any veteran who meets these qualifications now has this 2-year window that began in August of 2022.
That's correct.
Okay. So how will the Camp Lejeune claims and the litigation work? Because I understand there's a 2-step process. There's the so-called administrative claim, and then there's the litigation piece.
That's exactly right. We have to turn to the Camp Lejeune Justice Act, which tells us exactly how we're going to proceed with these claims. The first requirement is that we file what's called an administrative claim or a claims form with the Department of Navy. The Department of Navy will then have the opportunity to resolve the claim at what's called the administrative level before litigation, or they can deny that claim and have you proceed to litigation. So if once we meet that administrative requirement, then what we will do if we're not able to resolve it is file that claim in litigation in federal court and litigate that claim in full.
So many veterans are used to filing claims with the VA, and they file them on their own, or they could hire a representative. What do you recommend in terms of the administrative part of the claim? Because I'm guessing there's some technicalities here.
You're exactly right. And this isn't the traditional VA benefits claim that you can do on your own. This claims form has a lot of hidden nuances and a lot of hidden defects that can later affect your ability to pursue injuries and damages in litigation. So while it may seem like you can fill out this form on your own to its fullest, it can ultimately have greater effects down the road. So we always recommend that you have an attorney take a look at your claims form, review it, even write it so that they know how to avoid those nuances and defects that could harm your claim in the future.
So, for example, let's just take one example. I know in another area, the Federal Tort Claims Act, for example, there's a administrative process and there's a litigation process. And if that form at the administrative level isn't completed properly, for example, if you don't put a number of damages that's high enough, you're then bound by that number. So if you said I'm only entitled to $10,000 and then you go and litigate the case and get a $1 million award, you're limited to that $10,000 amount. Is something like
That's
that
exactly
the
right.
nuance that we're talking about here?
Yeah, that's exactly right. And you can be thrown out procedurally in federal court if that claims form is not filled out correctly. So it can just totally nullify your claim entirely. And that's what we want to avoid. We just want you to have the opportunity to review your claim with an attorney so that they can give you the green light of whether or not this should be then submitted.
Okay. So the other thing that many veterans are wondering and their families are wondering is, what is the impact of filing one of these claims for under the Camp Lejeune Justice Act on their VA benefits? And simply filing a Camp Lejeune claim does not impact the VA benefits. You don't lose your benefits by filing a claim. If the government offers you a settlement, You'll have the opportunity to evaluate the settlement as well as any potential offsets to VA benefits. If it's not a good deal for you, you don't have to accept it. It is our goal that a settlement is worth your while, regardless of any offset issues. In any event, the decision on whether to accept a settlement is ultimately the veterans. So they don't
Yeah,
have
Rob,
to accept it. Go ahead.
yeah. I just want to talk about that offset for a minute because I get those questions all the time, and I think that you can add on to that. So our understanding of what the offset is, and this is a clause in the Camp Lejeune Justice Act that ultimately says any settlement received will be offset by any benefits received from the VA. And what that means is that if you have been paid out disability benefits for an injury that has been directly related to Camp Lejeune, and that's the important part, directly related to Camp Lejeune exposure, then we ultimately have to pay that back to the VA. All it means is that you can't double dip in the pot. If the VA has paid something to you, you have to pay them back. But the important part about this is that it's those injuries that have been directly related by the VA to your Camp Lejeune exposure. And there's not many of those out there. So the offsets aren't necessarily going to apply to the greater majority of these claims, but it's something you need to be aware of. And I think, Robert, you can probably touch on that a bit.
So let's give an example. Let's suppose a veteran is 100% service connected and receiving over $3,000 a month for post-traumatic stress disorder. Not related to Camp Lejeune. They were fighting in a combat area and they have PTSD. That kind of a benefit is not going to be offset by the Camp Lejeune Justice Act. And so it's really important to understand that only those benefits that have been service connected as a result of Camp Lejeune exposure would be the ones that would be offset. And we don't know precisely how VA is going to go about offsetting those. Those things might be compromised by VA. As of this point, it's too soon to tell. But we do know that fact that if it's something other than as a result of exposure to Camp Lejeune, it will not be offset. So, yeah,
And
go ahead.
let me just, yeah. And what we also know is that you are entirely in control of your settlement. If you are offered a certain amount and what you do the calculations and it just isn't going to fit based on any offset or any VA disability benefits that you're receiving, and you don't think it's fair to you, guess what? We can go back and try again. And so that's what I think people really need to understand is that you are in control to some degree over what settlement you settle for.
The one thing we're certain about is you only have this 2-year window to find out the answer to what you're entitled to under the Camp Lejeune Justice Act. And if you don't file within this 2 years, you will lose your opportunity to do so. So at a minimum, we're recommending that veterans at least file the administrative claim, potentially go into court, figure out what that amount is, but don't lose this once in a lifetime opportunity.
That's exactly right.
So veterans and their families can fill out our form to find out if they're eligible. It'll be on our website. We're available to answer any additional questions you may have, and be on the lookout for our follow-up videos addressing the commonly asked questions regarding this lawsuit. Sarah, thank you for joining us. Any final comments from you?
The only thing I want to say is what a lot of people don't realize is that the Camp Lejeune Justice Act applies not only to veterans, but veterans and their families, wives, husbands, children, mothers, fathers who are exposed to Camp Lejeune's water. So it's wonderful that we've got all these veterans who are going to be able to seek some kind of settlement or recovery from this, but it's even better that we have their family members who have the opportunity to pursue this as well. So keep that in mind when you're looking at these claims.
So anyone who was living on the base for 30 days is eligible during that window from 1953 to 1987.
Correct.
Okay. Sarah, thank you very much for joining us. I'm Robert Chisholm from CCK, Sarah Papantonio from Levin Papantonio, and thank you.
Thank you.